Hi, my name is Brad Aldrich, and this week I'm going to be discussing how Aldrich Legal Services can represent condo associations or homeowner associations. We have a lot of experience doing this type of work, and I just kind of wanted to recap some of the common things that a condo association or a homeowners association may need from a law firm. First of all, there are bylaws that are put in place that each homeowner or condo owner is subject to. Now, those bylaws set out everything from what type of an appearance you can have for the structure, to what can be done in the common areas, to what the fees, the dues are, how they're paid, and how the association goes about enforcing these various rules, and also the association's obligations to the owners. Two of the most common reasons that an attorney is brought in to represent the association is for unpaid dues or for violations of the bylaws in general. The non-payment of dues, especially in our economic times, is quite an issue, and the association and there is a Michigan statute, a Condominium Act, sets out specifically how a condo association and then by proxy a homeowners association goes about collecting those dues. Typically you will see in the bylaws that there is some type of required written notice that has to be sent to the homeowner or condo owner by the association, either directly or through their attorney, setting out that they failed to pay their dues and they have a certain amount of time to bring that default current. In the event that they fail to do that, the association then has the ability to place a lien on their property to enforce payment, and worst case scenario, the association has the ability to file a lawsuit against the owner to get injunctive relief, meaning you can ask a judge to order something to be done or something to stop being done, or you could seek money damages, meaning the amount of the unpaid dues. The Act also provides that the association is entitled to any cost and reasonable attorney fees that is necessary to enforce the payment of the dues. Now, the second main reason that an attorney is brought in on behalf of an association is any other violation of the bylaws. And I've given some examples about an owner changing the appearance of their property to where they paint their house pink, or do something else that doesn't comply with the bylaws. They would rent out their property, and maybe the bylaws don't allow renting out of a condo or home in that association. In the event that that occurs, once again, the bylaws will typically provide for some type of written notice to the owner telling them that they are in breach of the bylaws and they have a certain time to correct it. And if they fail to do that, then legal action can be taken against them. And this is where, once again, the association has the ability to file suit if the default is not corrected against the condo owner or homeowner to force them to either stop doing something or get a judge to order them to do something, and certainly they can seek monetary damages on behalf of the association. In regards to the drafting of the bylaws, it's very important that a knowledgeable attorney be involved, because there are certain things that are allowed and certain things that are totally not allowed. For example, interest on any unpaid dues cannot exceed 7%. Anything above that is considered usurious and would negate the ability to collect any type of interest whatsoever. In regards to late fees on your dues, the late fees have to be reasonably related to some specific administrative cost, meaning the association cannot just put in there a $500 late fee for unpaid dues. They would have to have it somehow related to an expense they would incur out of pocket. So that is why it is imperative that condo associations or homeowners associations work with a knowledgeable attorney that can help them to not only draft the bylaws if necessary or amend their bylaws, but also to enforce those bylaws. And oftentimes the builder or developer will set forth the original bylaws, but eventually, as enough units or homes are sold, that association will be turned over to a new board consisting of owners. And the owners may want to look at those bylaws and amend those. They may want to adopt some memorandum to amend those bylaws if they do not think they're accurate. Once again, it's imperative they have a good, knowledgeable attorney in place to help with the drafting, the amendment, and certainly the enforcement of those bylaws. If you'd like any more information on this topic, please call our office. We offer a free consultation, or visit our website. Thank you.